Sharon. Good morning, everybody. My name is Wayne Carabas. I am joined by Jackie Kramer. We are both attorneys for the law firm Futterman, Lanza, and Pasculi. We are elder law and estate planning attorneys. We'll explain a little bit more what that means shortly. We also have with us Frank Columbia. He is a financial planner with Morgan Stanley. As we move through the presentation, everyone that you see here will have a chance to speak, and I'll kind of lay out the roadmap of the presentation shortly. First off, the estate planning elder law practice area. People don't think, oh, what does that mean? We are attorneys that help people kind of get their things in order. A lot of times, we do it through documentation, whether it's a, will, a trust, a power of attorney, a healthcare proxy, and really what these documents are meant to do is, show the client's intent as to what they want to happen when something happens, whether it's something that is, a planned event or something that just kind of, happens, an accident, a crisis, something like that. It helps the client and their families sort of navigate, whatever situation they're kind of faced with. In addition to the documentation and the sort of planning stuff, we also focus on, getting our clients benefits that they need and deserve. And, whether it's, the application for those benefits, the biggest one that we deal in is Medicaid. So we offer a wide range of services related to benefits, whether it's the application process or, planning leading up to the application process, to make sure that our clients are eligible and also that, we do extra things such as protecting assets to make sure that they're, they get to keep as much of their stuff as we possibly can. Given what's going on with the world right now with the COVID virus, people are extra concerned about their health and well-being and the health and well-being of their family and friends. Couple that increase in concern with the fact that people have a lot of, extra time on their hands because they're self-isolating, they're social distancing, they're spending a lot of time in the house. They have a lot of extra time to start thinking about, well, this is a bad time, am I prepared? Do I have my things in order? And I think a lot of people that have not done any planning, some of the stuff that we're going to speak about, they start to become a little extra worried, a little extra stressed out that they're not prepared. Obviously adding stress to an already stressful situation is not great. The goal of this presentation is to, all three of us are going to try and provide some information, very basic. I think that's going to apply to most, if not all people, so that, you can leave with a certain level of comfort. And of course, after this, you may have a little bit of a direction as to what you need to do, going forward. I am going to speak about some of the essential documents that we put in place for a lot of people, documents that everyone should have. Putting certain documents will really go a long way in helping you, start your plan. Then I'm going to pass it off to Jackie. Jackie is going to speak about Medicaid. It's the Medicaid related topics, including some updates that have popped up recently. I think that's a hot item right now, and I think a lot of people are tuning in to check that out. And then Frank is going to jump in and kind of round out the discussion and kind of show how the financial planning aspect fits into what we do on our end. So with that said, I'm going to get into the presentation. So I'm going to talk about documents that are what we call essential. Anybody who is over the age of 18 should have certain documents in place. It doesn't matter, if you're married, if you have kids, everybody should have these documents that I'm going to talk about. I'm going to start it off with the healthcare proxy. The healthcare proxy is it's a document where the principal, who is our client, will name an agent, to make healthcare decisions on their behalf when the principal cannot make those decisions for themselves. So I have to stress the authority of the principal only is triggered, or the authority of the agent is only triggered when the principal cannot make decisions and communicate to the medical professionals themselves. So saying, for example, take myself and my wife, we're each other's healthcare agents. If something bad were to happen to me and I get into a car accident, or I have some complications after I contract the coronavirus, and I am incapacitated and can't make medical decisions on my own, my wife can step in and speak to the doctors about my treatment and handle those sorts of decisions. I don't have to worry about her, barging in after a routine, medical procedure where I'm completely fine and recovering. And, I don't have to worry about her barging in and demanding that the doctor pull the plug on me, maybe because she was a little upset with me or something. But as long as I am able to make my own decisions, the authority of the agent isn't triggered quite yet. I think a lot of people assume that because you are related to somebody in a certain way, that you can make decisions for them, and that's just not true. So a parent for a child, a spouse for the other spouse, just because you are related in that way doesn't mean you have the authority to make those decisions. What happens if you don't have this healthcare proxy in place? Take the same example where I am incapacitated. My wife can't just step in and say, hey, I want this to be done and that to be done. The doctors won't, listen to her, and they don't have to, because she doesn't have the authority. What she would have to do is start what is called a guardianship proceeding, where she'd basically go to the court, go to a judge and say, hey, Wayne can't make decisions for himself. He is incapable. He needs these decisions to be made, so I should be the one to make those for him. And essentially, it's a lengthy process. It costs time, it costs money, and it's I'm already laying in the hospital, so and to have her go to court on top of that, it just makes a tough situation much worse. So you could see where having this simple document in place can help avoid all of that headache of having to go to court to start a guardianship proceeding. As far as picking an agent, you can only have one agent at a time, and obviously it's someone that you should be very comfortable with, someone that you trust, and the most important thing is that the agent know what you want. Because what is essentially happening, you are nominating somebody to make decisions on your behalf as if you were the one making them yourself. So it's important that you communicate with the agent and have those conversations. Now, obviously, you're not going to be able to touch on every potential situation that you might come across, or treatment question that might come up. But I think if you have some conversations, you can kind of bring across a theme that will guide the agent as they sort of navigate any kind of issues that might arise if you were to become incapacitated. I think it's also important to mention to have a backup named. Having a backup agent is important in case, obviously if your primary agent, something happens to them. In the example of myself and my wife, we need to have a backup in case we're together and there's an accident. Then someone else can come in and make those decisions that need to be made. I think this document falls under the category of ones that you do it because it's responsible to do, and hopefully you execute it and file it away, and you never have to go and actually use it, because those times that you're using it, it's just going to be a very, very difficult time. But like I said, it really makes things a little bit easier if you do have this document in place. The next document that I'm going to speak about is the power of attorney. This is the financial document. Just like the healthcare proxy, you're going to be naming an agent to make decisions on your behalf. But this time it is for financial decisions and financial transactions. It's essentially anything that you yourself can do as far as a financial decision or transaction goes. Your agent is going to be able to do that as well. Unlike the healthcare proxy, the authority of the agent begins as soon as you execute the document. So it's not that the agent steps in when the principal cannot. As soon as you sign it, as soon as you execute it, the agent can go out right after that and begin to do things on your behalf. We draft the very broadest and most comprehensive powers of attorney that are available. The more authority and the more actions that you allow your agent to do, the better it is when it comes to planning and doing kind of what we need to do. It's always better to have a broader power of attorney than a more narrower one. We include what are referred to as statutory gift riders, which allows the agent to make gifts of the client's assets to other people, including the agent themselves. Where this often comes up is just, it's not really a gift, it's more of a transfer, out of one person, out of the client's name into somebody else's name, so that that client can then become eligible for some sort of benefit, like Medicaid. We also draft what are referred to as durable powers of attorney, which means that the authority of the agent survives the incapacitation of the principal. Otherwise, once the principal becomes incapacitated, then the power of attorney is cut off, and the agent can no longer act. In our line of business, when we're doing the planning that we're doing, especially when bad things happen, it's important that we have that durability aspect, so that we can kind of carry on and continue to plan, even if something were to happen to the principal. When we're picking an agent, you could have multiple agents, multiple primary agents, or you could have one. Similarly with the backups, you could have multiple agents or just one. But again, you should have a backup in case something happens to the primary agent. I think when you have multiple agents, some people would prefer to have it that way. You could either have the agents act together or separately. When they're together, both agents have to go to each place and essentially sign off on any action that they want to carry out. When they're separate, it's like having two different agents that can go and independently carry out different actions whenever they want. Certainly when there's the acting separately authority, it's more convenient. It has the it's like two people can be in two different places at one time. But when you have the acting together, it's more of a checks and balance situation. So it's whichever the client prefers. when you're talking about the agent, obviously this is someone that you should have the utmost trust in, and someone that you really uh, has their stuff together, because they have a lot of authority to do a lot of things. They could go and empty a bank account, or do something quite bad if they were not trustworthy, and not somebody that has their things together, that has some sort of underlying issue that might compromise their loyalty to the principal. So it's important to kind of have that trust level in the agent, because there's so much that agent can do. I think again, this is another situation where a lot of times people are like, oh, we're related a certain way. It's my parent, it's my child, it's my spouse. So I could just pick up and carry out their financial business. Again, that's not the case. Without the power of attorney, you are going to have to pursue the guardianship, just like in the healthcare proxy. I think at this point, that's what I have to say about those two documents. Generally speaking, it's great to put these documents in place, but it's also good to revisit your documents from time to time to make sure that what you have, stated in there, and the people that you are appointing to these positions, everything still makes sense. A lot of things can happen. Maybe, for example, a married couple might have executed documents, years ago, and now, maybe one of the spouses has passed away. One of them is lost capacity because of, dementia or something like that. So the well spouse should remove and replace the spouse who's not well any longer. There's also things like, divorce, or maybe something, happens between the principal and the agent, where the principal no longer has trust in the agent. Under that circumstance, certainly the principal should revisit the documents and replace as necessary. It's very simple once the documents are in place to then go back and make adjustments to some of the, especially the people that are named in those documents. Another thing about documents that are in place, the power of attorney, for example, it's great that if you have one in place, but you should always understand who is the one that drafted that document. I think certain lawyers in different practice areas might draft a more narrowly focused power of attorney than what we would offer. And I think it's not that that particular attorney was wrong, or that they don't know what they were doing. It's just that they didn't really consider the things that we would consider, and they didn't expect the power of attorney to do what we expect it to do. So I think it's certainly important to have your documents, reviewed by an elder law estate planning attorney, just to make sure that they're properly executed, and they contain all the bells and whistles that we would need to use. A quick real life story. We had a client. She came in, her and her husband, her husband's in a facility. They had executed powers of attorney years earlier. And this particular, these clients, we needed to move assets out of his name into her name so that he could receive some benefits that we were pursuing. And when we looked at the power of attorney, it was lacking the statutory gift rider. The reason being, they had the power of attorneys executed in contemplation of a real estate transaction, and the attorney running that transaction didn't need a statutory gift rider, and frankly wasn't interested in putting it in, and there really wasn't any reason to include it, and so they went without it, and they got through their transaction. But now, trying to use that for a different purpose, it was not something that we could use to execute on our plan. And so this couple who thought they were prepared and had the right stuff in place didn't have exactly what they needed. Fortunately, in this situation, the husband still had the capacity to re-execute a power of attorney. So we were able to go to the facility, get that signed up, and got them in the place they needed to be. But you can see if they were if he was lacking capacity, then it would cause a whole additional problems, because of the missing gift rider there. That's what I have. I will say one thing. I think maybe I'll preempt some questions about executions of these documents. Normally people come into the office and the client signs, and then oftentimes you'll also need witnesses and the attorneys, either as a witness or notaries, and obviously before all the self-isolation and the social distancing came into play, everyone would either come to the office and we could all sit down and sign it. We would go to your house or facility and sign it there. Now that we are unable to do that, we either have to get creative, or there's been some guidance from New York State about how we can continue to get these documents in place, because frankly they are necessary, and sometimes time is of the essence. So what we do now is before this actually really became official as far as lockdowns, we were doing things like delivering the documents to clients and kind of looking through windows at their house to see them sign, so that we could officially witness the signings, and then we would get the documents back. We've even met some clients in parking lots to have the executions go on. I think if authorities rolled by at that point, I think we looked a little more shady than we actually were. We were just trying to get some documents signed up, but now we have the ability to execute documents and witness and notarize documents electronically. New York State has put out some guidance on that, where we can deliver the documents to the client, and then we could watch, essentially what we're doing now, some video technology, whether it's on your phone, FaceTiming, Zooming, whatever. We can kind of witness it that way, so that the client can sign in the comfort of their own home, and then they could fax or email it back to us, and we can kind of finalize it. So certainly the need for documents hasn't ceased because of this pandemic. It just made things a little bit more difficult. But if you are in need of these documents, we certainly have the ability to get in there and get them executed. So with that, I'm going to turn it over to Jackie now. I see there's a couple questions. I will look at them. I will answer them when everyone's done with their engagements, their speaking as well, and then we'll see how much time we have left. So with that, I will introduce Jackie.
Good morning, Jackie Kramer here. I'm here today to discuss home care Medicaid, nursing home Medicaid, and the legal strategies that we implement on a daily basis to protect and preserve your assets. This discussion is always important to have, but it's even more important in light of the pandemic as people continue to fall ill. The virus is kind of like a wake-up call to everybody to make sure that they have a good plan in place before it's too late. So as everyone's quarantined, sitting at home with extra time on their hands, I want to stress that this is really a great time to be thinking about creating a plan or reviewing one if you already have one in place. So as you may be aware, the average cost of a nursing home on Long Island is about $15,000 a month. So that's almost $180,000 a year. If you need a home health aide to come into your house and you hire somebody privately for $25 an hour, 8 hours a day, 7 days a week, that adds up to about $6,000 a month. So the cost of care is very expensive. So without having a proper asset protection plan in place, the assets that you've worked so hard for your whole life are really vulnerable towards the cost of your care, which obviously will result in a substantial loss of wealth. So let's dive in a little bit about the ways that we can pay for long-term care. Okay, so there's really three options. The first one is you can pay privately. You can pay out of pocket with your own money. Two, you could have long-term care insurance, which I know everybody says is expensive, which may be the case depending on your age, your health, all of those things. But long-term care insurance is really good for home care purposes and also for assisted livings, really important for assisted livings because most of them on Long Island are private pay and they do not accept Medicaid. And then the third option is the government, Medicare and Medicaid. So Medicare is a federal entitlement program that doesn't have an asset test, so it doesn't matter what you own. And it's available for those over 65 or people who are under 65 who have been on disability for 2 years or more. But Medicare only covers skilled services. So services under a nurse, a doctor, a therapist. So hospital stays, rehabilitation in a nursing home, things like that. It's not going to cover unskilled services like activities of daily living. So if you need to come home with an aide or you're staying at the nursing home for good and you don't have long-term care or you can't prove that you're eligible for Medicaid, you're going to be paying out of pocket for these services. Okay, so I want to really be clear on Medicaid that you don't actually have to be poor to qualify for Medicaid. You just have to be poor on paper, which is where we as elder law attorneys step in to help transfer assets out of your name to make you poor on paper to become eligible. So what assets can you have in your name and qualify for Medicaid? So let's go through it. You're allowed to have a primary residence, but I put a big star next to that because although you can own a primary residence, let's say that was your only asset, you could still own it, you could qualify for Medicaid, they'll put you on, but they could put a lien on the home or recover from your estate when you go to probate. So we always want to plan with moving the house out of your name in order to protect that. So you're allowed the primary residence with the big star next to it. You're allowed to have a prepaid funeral as long as it's in an irrevocable funeral trust. That the funeral home would help you set that up. So you could prepay for everything and Medicaid won't count that against you. You're allowed to have personal property. They're not interested in your jewelry, your furniture, your artwork. You're allowed all of that. You're also allowed to have retirement accounts, 401ks, IRAs, 403bs, as long as we help you put them into a special payout status to turn it into this income stream that will count as income. The principal in those retirement accounts will not count as a resource when you go to apply for Medicaid. And anything else other than what I just said must be below $15,750. So that's your bank accounts, stocks, bonds, cash value of life insurance, other real property you may own, like a vacation home, rental properties, things like that. So that all must be out of your name and leaving you with $15,750. So most people have more than that, right? So we need to transfer assets out of your name, but that's where we can help you. But our plan will really depend on whether you're planning in advance or you're planning in a time of crisis, meaning you need home care now or you need the nursing home right now. So as you may be aware, the nursing home has what's called a 5-year look back. And basically what that means is when you go to apply for nursing home Medicaid, they will do a 5-year audit of all of your accounts, your assets, and they want to see if you've made gifts in the last 5 years to your loved ones to see if you're trying to make yourself poor on paper, right? And if they see gifts within the 5-year period, they're going to tally them up, and they will take that number, divide it by the regional rate, which they say is $13,000 roughly. It's really $13,407, but let's say $13,000 flat. And that's what they say is the average cost of a nursing home. So they take the total amount of the gifts, they divide it by the regional rate, and whatever that quotient comes out to be is how many months you are ineligible for nursing home Medicaid, meaning you'd have to pay out of pocket first before Medicaid would kick in. So there are some exceptions to this rule with the 5-year look back, where they will see that you made transfers to particular individuals or to trust that you will not be penalized for. So they will always do the 5-year look back no matter what, but depending on who and where you transfer assets to, it will make a difference. So let's talk about these exceptions. One of them is transfers to a spouse. So if your loved one goes into a nursing home today and has hundreds of thousands of dollars in their name, and you're living at home in the community, not on Medicaid, we can actually transfer all of the assets into your name as the healthy spouse and qualify you for nursing home Medicaid the following month after we get you down below the $15,750. So the spousal transfer rule is really, really key in a lot of cases. The second exception is disabled child. So if you have a child who is on disabilities, or maybe they're not on Social Security disability because they don't qualify for that, but they are disabled and we can prove it, we can transfer assets to that child. You have to be a little bit careful when we're looking at a disabled child, because maybe they're on Medicaid, maybe they're on SSI, and we don't want to maybe transfer assets right into their name because it will kick them off their own benefits. So that's where maybe we set up a trust for the sole benefit of that disabled individual. The third exception applies for the house, your primary residence only, and you can transfer it to a caretaker child who's resided in the home for at least 2 years continuously before you went into the nursing home. So if you break that 2-year chain, where you were living there for 40 years and then you just moved out, and 3 years after that you went into the nursing home, you can't transfer your house to that caregiver child because they weren't there for 2 years right before going into the nursing home. You could transfer the home also to a sibling who has an equity interest in the home and has been residing there for at least 1 year. That's less common, but it does exist. And the last exception is you can transfer assets to a trust, a sole benefit trust, for any individual who is disabled and under the age of 65. So maybe you don't have any of the other exceptions and you have a grandchild who's 20 years old and disabled. You could transfer all of your assets at the last minute into this special type of trust, and that would not affect you with the 5-year look back rule. So those are the exceptions that we apply often when we're seeking Medicaid in a crisis situation where planning hasn't been done in advance, or maybe some planning was done and you still had certain assets in your name that we had to move out. We could use those exceptions. Now, there's even a way, if you didn't plan ahead of time, that we could still save money. We could save about 40 to 60% of the assets. So this is a true crisis where we have no exceptions, you never did any planning, money's in your name. What do? We could still save about half of the money with this gift and promissory note planning technique, also known as the rule of halves. It's kind of complicated. I don't have that much time today to get into the mechanics of it, but basically we get all the money out of your name by gifting half of the money to a loved one, and then we loan half to the loved one, and the loan money goes to pay through the penalty period that will be created because you made a gift within the 5-year look back. So I don't expect anybody to understand this in great detail because I don't have time to go into it, but do know that even in a worst case scenario, we can typically save about half of the money. So let's talk a little bit about community Medicaid, because there's a lot going on with that right now. There are changes coming up as of October 1st, 2020. There is going to be a look back for home care Medicaid. Currently, there is no look back. You could transfer all of your assets right now. It's April 16th. You could transfer all of your assets out of your name before May 1st. And when May 1st rolls around, you would be eligible for community Medicaid. There is no look back. However, moving forward, they are going to impose a 30-month look back, which is 2.5 years. So it's going to be similar to nursing home Medicaid. I do know somebody had asked a question that will they be grandfathered in if they already applied for community Medicaid once the laws change in October? I don't know right now. A lot of stuff is up in the air with this still. We all have questions, so I don't think it would really be fair if they went back to people who already applied for Medicaid before October. But I don't know with certainty. But I do know once October 1 rolls around and you do apply in the month of October, they are going to do the 2.5-year look back. So if you do make transfers now, it does appear that if you apply October 1 forward, that these gifts that are being made now may get caught in there. But like I said, this is still kind of up in the air. We're waiting for more directives to come down and to have more discussions with our colleagues about the mechanics of how community Medicaid is going to work moving forward with these changes. They also made some changes with respect to the medical portion of how you can qualify for home care. You now have to have, need 3 ADLs. You need assistance with 3 activities of daily living in order to qualify for home care services. It used to be, I think it was only 1 or 2. So now you have to have at least 3, unless you have a diagnosis of Alzheimer's or dementia. And in that case, you'll only need 1 ADL. Assistance with 1 ADL. So that's a little bit about the assets for community Medicaid. The test is the same, the threshold of the $15,750. So all of those assets I mentioned earlier apply for both nursing home and community Medicaid. So let's now talk a little bit about how to transfer assets out of your name. And there's really 2 ways. One is you can transfer assets to your kids, to your loved ones, right? To plan ahead of time. Or you could transfer assets to an irrevocable Medicaid asset protection trust. I've heard a lot from clients when they first come in that, oh, isn't it easier to just transfer the assets to the kids and it's less expensive? Yes, that may be true, but we often don't advise outright transfers to the kids in a majority of our cases because there's a lot that could go wrong. First of all, you lose a lot of control. You actually lose all control of the asset. So let's say you transfer your $100,000 bank account to your kids. Now it's their money. They can do whatever they want with it. You have lost complete control. Now what happens if they go through a divorce? Now your money that they're holding for you might get tied up in their divorce proceeding. What if there's creditors? What if they get sued by somebody? They get in a car accident and injure somebody. What if they go through a bankruptcy? Same thing. What if they predecease you? Now their money is going to go under their will if they have one, and it might be going to a daughter-in-law or a son-in-law that you may not be a fan of. So these are all reasons to maybe not make transfers outright to children. There's also tax consequences, capital gains issues with outright transfers to kids that I don't have time to get into. But the Medicaid trust, the irrevocable Medicaid trust, is usually a better option because you would retain much more control. So the Medicaid trust works in a way where you move assets. Let's say we take the home and we put the home in this trust. if you stay out of the nursing home for 5 years from when you put the assets into the trust, the house is off the table for Medicaid when you go to apply at the nursing home 6 years from then. So you put the house in there, you have the right to live there for your lifetime, nobody can kick you out. You maintain all of your real estate tax exemptions, so your star, enhanced star, seniors, veterans, all of that's going to stay the same. If you want to sell your house, you just have to go through your trustees, who cannot be you. So it has to be one of the kids or, some other relative. It cannot be yourself as the trustee. So you would tell the kids, hey, I want to sell my house. They would sell it on your behalf. And you're also allowed to purchase a new residence inside of the trust. So let's say they sold your old house, you moved to Florida, and you want to purchase a condo down there. The trustees would purchase the new condo inside of the trust on your behalf. Let's say your trustee's not listening to what you want to do with the trust. You could remove a trustee at any time as long as you're mentally competent to do so. You would just call us up and we would help you with that. And then on your passing, the trust works just kind of like a will. It disposes of your assets and the trust will name beneficiaries. Typically children or siblings or nieces, nephews, things like that. And you could also change the beneficiaries at any time. So a lot of people get freaked out by the term irrevocable. It sounds like it's set in stone, but it's really not. So you could change the trustees, the beneficiaries, and let's say you even had to revoke the trust. Let's say we set this trust up and 2 months from now you went into a nursing home. You can actually revoke an irrevocable trust with your consent as the creator and the consent of the beneficiaries. And let's say one of the beneficiaries won't consent. Maybe you had a falling out with one of them. You could change the beneficiary first, and then we just need the other people who remain on there to consent. So I'm just trying to demonstrate all of the levels of control that you would still maintain with this type of trust. So we're running out of time here. I just briefly want to touch upon income because that is a little bit different for the nursing home versus home care. If you are in a nursing home as a single individual, you're not married, you're only allowed roughly $50 of income in your name. Anything else over that, your Social Security, your pension, your distributions from your retirement accounts are going to get paid to the nursing home. And that's called NAMI, Net Available Monthly Income. If you go home, the rules are a little different. You're allowed $895 of income, and anything over that, you can save it. There is a way to protect your income if you do go home with what's called a pooled income trust. And basically, you send your extra income over the $895 up to this pooled trust company. It's a charitable organization for the benefit of disabled individuals. And you will then send your bills that are in your name up to that pooled trust company, and they will pay your bills on your behalf. So it's this indirect way of letting you keep your income. So I see that I'm out of time. I just want to make one quick point, a really hit home point, and that is if you're not sure if you have something that needs to be put in place, or if you're unsure if the plan you currently have in place is still sufficient, at least just pick up the phone or shoot an email to the attorney's office. That one phone call or email really can be life-changing for you. So now I'd like to turn the mic over to financial planner Frank Columbia, and he's going to just briefly go over how he kind of interacts with what we do and to work as a team together.
So good morning, and I appreciate the time. I have a couple of minutes to speak today. And first, I just want to say again, I'm Frank Columbia. I'm a senior vice president at Morgan Stanley. I've been with the firm for 23 years and have seen a lot of crashes, evolution, and things change in the business. And what I find to be successful with our clients is that they have a goals-based financial plan. You know, whether that we're in the accumulation phase of saving for retirement, or we get into retirement where we want to collect income and keep our money safe, or we're thinking about the transfer of wealth eventually, how do we successfully get that done? So what we do is we understand our clients' needs, wants, and wishes. We commit that to paper. We create a written financial plan. And what we find so critical, and especially as you guys have been talking about, the biggest hot button in the past couple of years is the transfer of wealth, protecting my money. How do I protect the family and have that legacy continue on? And I find that as we go through the financial plans and we get to the estate planning portion, there's two ways to do it. We can do it with pre-planning, with estate planning, where it's not crisis mode, where mom and dad are not, ill, and there's not a significant issue going on, or you're in crisis mode, and that's when you talked about, Jackie, protecting, not having the planning and protecting 40 to 60% of the money. We want to help the clients protect all their money. And so the relationship that we have, with the firm is one when we go through the financial plan and we understand all the numbers, we then have to talk about the estate planning. We set up a meeting, and there's some things that we specifically help with in doing the estate planning. And some of it is in the retitling of assets, right? Another one is producing income because there are laws and restrictions and things. We demystify and we talk about what assets are, can be placed inside a trust and not inside a trust, and making sure that the beneficiaries are properly updated. So I find that there is a very close strategic partnership relationship that we have with the firm, and they are trusted partners of ours and critically important to help round out the full financial plan that we do. And so with the relationship that we have is that we are doing complementary financial plans for the referrals and clients that we work with, because we don't want to have a barrier with the standard of care that what we both want to accomplish. And so we want to keep people on track, within their plans. Jackie, what would you say, in dealing in being connected to the financial advisor, the financial plan, what do you see as the overlap between both of us?
Good question. I mean, we work with, it really comes in for planning purposes. I mean, I meet with somebody and I take a look at their statements that they may currently have, and I see the pie chart on there saying, this 85-year-old woman is invested all in the stock market. I mean, that number one red flag. Nobody of that age should be invested 100% in the stock market. That's just too dangerous. So something like that, I would refer them to somebody like yourself, right? To take a look and help them fix their plan to protect their assets. Or maybe they have assets in 20 different places. They don't even know what they have. You can help us consolidate all of that into one portfolio, or maybe a couple, instead of having 40 different assets everywhere that's not being managed by anybody. It kind of puts it all under one roof.
Right. So you see that there's an overlap, right? So what's the process of, okay, so Frank Columbia is the financial planner. He creates this written roadmap. We take a collection of understanding what the client's needs, wants, and wishes are. We take an asset inventory, which this financial plan then is a tool that when we come to your office and we sit down and we're there and the client's there, that we're able to go off and base some of their concerns off of there. So you have that information already. And then what I like to do sometimes is, there's a lot of terms and things that are thrown around, and by understanding what the client's needs are, we're also able to demystify some of this stuff, because it could be stressful. These are some of the biggest financial decisions that people are going to make, is with their money, with their loved ones, assisted living, long-term care, and there's so much to learn and understand, and we work closely together to make that happen. So process-wise, we get that information, we create the written financial plan, we understand their needs, wants, and wishes, we create this roadmap. We also look at we do a risk analysis of their investments. Like you said, you look at these pies, you understand that although the investments over years may have been fine for then, but is it fine for okay? And I think that, most of the phone calls that I've been fielding over the past month, especially with regard to COVID, is my money safe? Is it positioned properly? Am I going to continue to get my income? What happens here? So there's just so many important questions I get asked. So with that in mind, if anyone who's participating here is interested in asking questions about the markets, having a risk review done in their portfolio, having a financial plan done, we're happy to do that. Yes, and just by the way, my financial information, I know there's a lot of, there's the chat ability on a lot of the screens. My information's at the top, but always feel comfortable to email or ask, law firm, and they'll be happy to provide it as well.
All right, so I guess we're gonna open the floor now for some of these questions. Wayne, you've been taking a look at some of these questions throughout. Oh, he's still on mute. There you go.
There you go. Let's see. There was one question about promissory note planning, whether it's used mostly for nursing home care, but what with the new look back for community, whether it can be implemented for that as well. I think it's certainly something that we're gonna look to. I as Jackie mentioned, things are still kind of in flux with this. But just as it's used to kind of address a crisis with the nursing home care community, it may be a tool there. I think a lot of times with the nursing home, it's more of a crisis for a nursing home because there's more care and more higher level of care needed. But certainly, in trying to get somebody eligible for community Medicaid with the new rules, it's certainly something that we're gonna look to and see kind of how that goes. Kind of in the early weeks and months of the new the transition to the new rules and the new system.
I think one point on that is, if we do the promissory note planning for the community Medicaid, I think the hard part is going to be figuring out what is the cost of care. When we do a promissory note for a nursing home case, we know what the daily rate is going to be. We know exactly what the cost is. If somebody hasn't had an aide in their house yet, how are we supposed to know what that cost is going to be? So that's one of my concerns I have with that, but we'll see moving forward how that works out.
Yeah, and a lot of, I think there's people that are kind of looking for hard, guidance on this new community Medicaid situation. I think unless there is, actual guidance from, the lawmakers, it's really kind of a wait and see. Some of the early cases, will kind of, push certain, questions and we'll see how the system kind of handles them and responds to them. And from that precedent is where we kind of get comfortable, as to, how this is going to work kind of regularly. But unfortunately, there's a lot of, questions that are unanswered and unanswerable, just because we don't have the solid guidance, and we don't really know how this is going to kind of play out.
Exactly. I see a question here. Just put house in trust for my 93-year-old mother. Investments have yet to go in. Is there a time consideration to put investment dollars into the trust? I mean, I guess it really depends on your mother's health. If she's still in good health, and you think she's going to make the 5-year look back for the nursing home, I think that it would be worth doing it sooner than later, obviously, because time is the essence here, with her age, being 93. Because the later you wait, the more you keep pushing that time frame back, and it's less likely that she's going to stay out for the 5-year period.
Jackie, one thing, if you don't mind just interjecting there, right? A lot of the times this 5-year time period is looked at as a hard number. Well, if I started 5 years ago and I made the 5 years, I'm okay. But what if I started 3 years ago? And although we did all this great planning, now everything is cut short, and then the home comes. Do I lose the full benefit, or do I lose part of the benefit?
So your question is really, if you put the house in and and that made it 3 years, you're saying?
Yeah, so let's say, your planning is 5-year planning, right? To have it totally gifted out of your name to get the full benefit of being out. Okay. But what if it only goes 3 years? What if that spouse passes away before that 5 years, or grandma, whoever it may be?
Yeah, if someone passes away, that's less concerning than if somebody's going into the nursing home within that time frame.
Right. So let's say then the nursing within, so instead of making the 5 years, it's 3 years. Is there do you get 3 years of benefit? What happens there?
Right. What happens is we'd really have to do the math when the numbers, we have to run where in the timeline we are. So let's pretend instead of 3 years, let's just say it was 1 year. If it's 1 year, we're going to undo the planning at that point, because we're not going to pay privately for 4 years to make it through the 5-year look back, right? Let's say you made it 4 years and 11 months, and we're so close to that 5-year period, I would just tell you to pay privately for that 1 extra month, and then we can apply for Medicaid, and we would have made the look back.
Right.
So depending where we fall in the 5-year mark, depends on what kind of plan we're going to do. But like I said, if it's soon enough in and we don't have the assets to be paying privately, it might be worth revoking the trust and then maybe making a transfer to a spouse or to a disabled child, or if we don't have any of those exceptions, doing the promissory note to save about half.
Gotcha. Thank you.
Right. Well, next question is in regards to updating documents to address changes. People moving away. Our documents have names, phone numbers, addresses included, depending on the document, and whether if people move, that sort of thing. Do the updates need to be made? The point of having the additional information in addition to the name is to identify the person. If people move, it's really not essential that you update things. For example, if somebody gets married and their name changes, you'll still be able to identify that person, and it's not essential that you update just for that. But as I mentioned, as you go through and make changes for other reasons, whether you're making changes to other parts of the document, it's then good to go back and kind of refresh, and update all the information that needs it at that point. But standalone, those different, those small changes aren't necessary to make the updates.
I do want to make one point on that. If you, as the client, are moving out of state, so let's say you're in New York and now you're moving to Florida, you should really have your documents reviewed by an attorney down there. And you're probably at a minimum going to want to redo your advance directives, the power of attorney, the healthcare proxy, the living will, because a lot of times the financial institutions won't accept these documents, even though they are legally valid and should be accepted. They may not do so. Just as a practical piece of advice to you guys, you might want to have that updated.
Yes, good, great point. I think we're just about out of time, so we'll continue to go through these. If we can answer them to the individual, we'll do that. If it's helpful, to the broader group, maybe we'll put together just a follow-up email so that people can have the benefit of the answer to that question. So I'd like to thank everybody for tuning in. Again, we thank you for spending the time. Our contact information is up there. If you have any additional questions that you didn't get to ask, or you wanted to just bring it up to us directly, you could reach out by phone or email. We have 3 offices. I forgot to mention. As the screen shows, one in Smithtown, one in Bayshore, one in Garden City. Jackie is primarily in Smithtown. I am in Bayshore, but we and all the other attorneys, we bounce around to wherever is convenient for the clients. And once restrictions are lifted, we also make house calls and facility visits as well. So with that, I thank you again, and everybody, if stay safe, and enjoy the rest of the day. All right? Thank you.
Take care. Thank you.